And we're back looking at the Constitution line by line. I'm Don Frazier.
I'm Paul Fabrizio.
And we're in the 14th Amendment, kind of the third segment of the 14th Amendment.
And it's really still, we're in Section 1, but we're in the third segment of Section 1.
Yeah. So
just to confuse everybody.
Section 1 was really about making sure that the newly emancipated population of the South has protection, legal protection.
They're citizens.
They're citizens with all that entails.
Right. And then the second thing is that the states can't take away their rights.
That they can't take them away because they were trying.
Right.
There was a move afoot to try to render them politically inert and socially inert and economically inert, essentially trying to reestablish the Old South. So what we're talking about here is a remedy.
Mm-hmm. A constitutional remedy.
A constitutional remedy, an antidote to this sort of poisonous atmosphere in the South during Reconstruction. You know, Southerners are busy trying to figure out how to get around all these new rules and regulations, and the federal government's trying to keep up by making this part of the document, capital T, the document.
Yeah, it's like the federal government is coming along with a hammer trying to mash down any attempts to undo what the Civil War achieved.
And who's driving this now is Congress.
Right. The radical Republicans.
Yeah, the radical Republicans are driving this hard. Presidential Reconstruction is kind of played out. Lincoln had a fairly lenient program. We would never know what it would look like in full flower because he was assassinated. But his successor, Andrew Johnson, is essentially, his wings are clipped by a very hostile Congress that resorts to doing things like impeaching him and things like that to keep him essentially politically powerless. So now Congress is saying, you know what, Reconstruction's now our jurisdiction, and here's some things that we're going to do. So when this was all still part of the 14th Amendment, which is proposed in 66,
ratified in 1868. So the third part of it, and we're talking about denial of power to states, so states shall not. But it goes on to say, nor deny to any person within its jurisdiction the equal protection of the law. Okay.
Because you know what's going on.
Yes.
There is physical intimidation going on. This is about the time that we have the rise of the Ku Klux Klan, for instance.
Yes.
Whose original targets were Northerners that had come down to essentially assume positions of power within Southern society because most of the Southerners had been disenfranchised because of their participation in the rebellion. So there just wasn't enough people to man government. Mm-hmm. And so Northerners are coming down to take advantage of that. Those are the carpetbaggers. Mm-hmm. And there's Northern regimes that are being set up in Southern states that the KKK is trying to intimidate, but they very quickly realize that these Northern regimes in a Southern costume are being supported by enfranchising blacks. Mm-hmm. So then the KKK says, well, if we intimidate the blacks, then they won't have the political base in order to bring about their particular view of what this state ought to be.
Okay.
And so, in Texas, I can tell you how this plays out. A lot of times, shooting a African American dead in a saloon didn't get you convicted of anything. But if you shot a white man,
it did.
It did. Well,
yeah, and this goes back to what I said in an earlier tape. The 14th Amendment is talking about us as groups, as members of groups. And you have to, and let me just read the words again. Nor deny to any person within its jurisdiction the equal protection of the law. People have to be treated equally.
Correct. Rule of law is kind of a basic tenet of American civilization.
And this is something that the United States has struggled with. What does it mean to treat people equally? What we're clearly talking about here in modern eyes is discrimination.
Correct.
can you discriminate? And it turns out that the answer to that question is yes, you can discriminate, but it's who are you discriminating against? Why are you discriminating against them? And
how are you
discriminating against them? And you go back to where the law's intent was. We've got to get the former slaves, the emancipated slaves, we've got to get them into society, equal members of society. And that was the intent. And it's evolved over time into a discussion about discrimination and who can we discriminate against and who can't we discriminate against. And the Supreme Court really, in looking at it, has developed a test.
Really?
Love these tests.
Yeah.
And one of them is what we call a reasonable basis test. Is there a reasonable basis for discrimination? And you think about groups that we discriminate against. For example, driving. We don't want 10-year-olds driving cars. That is blatant discrimination, but it's reasonable discrimination. Okay? We don't want 22-year-olds collecting on Social Security. Again, reasonable discrimination. Okay, so that is acceptable under the Supreme Court's formula.
Sure.
Okay, then there's a group where we call intermediate discrimination or intermediate basis for discrimination. And this one is a really different one. You touched on it before, and this is women. And this deals with the question, is it ever okay to discriminate on the basis of gender? And what you always confront is the question of draft and registration.
Sure.
And because of that, the answer is yes, sometimes discrimination is okay. Government-sponsored discrimination on the basis of gender is okay. When it comes to the draft, does it apply to other things, like pregnancy, for example? And what we've seen over time is an evolution of the law where it's really no longer acceptable to discriminate against women, but in the draft. And until we as society draft women, there will always be that exception in the law.
Yeah, it's an exception that it just drives me crazy.
Okay.
You know, and I've raised two girls.
Two daughters, yeah. Then the third basis for looking at this is what we call strict scrutiny. And this is where if you're going to do any kind of discrimination, is it acceptable at all? And you're going to look at it with the most strict lens. So can you ever discriminate on the basis of race? If a government is going to do that, it better have a really good reason. And this leads to the question of affirmative action,
Sure.
for example, in graduate school admissions or whatever. Is it ever acceptable to discriminate on the basis of religion? And that, of course, you think about various things like people who don't want to bake cakes.
Sure.
Taking a case for same-sex couples.
Sure.
Is that if they're doing it on a religious basis, is it okay to discriminate?
Or opting out of healthcare laws because
of,
it pays for contraception.
Yeah, or abortion or something.
Yeah.
So are those discriminations? Yes, they are. Are they acceptable? And that's where the court says you look at it in the most strict kind of way. It starts from the basis of no discriminations allowed, but then we need to look at it very, very carefully. And limited discriminations might be allowed, but just very, very limited.
What strikes me about all this, well, keep going.
Okay, there's one other thing we need to talk about, and that's discrimination on the basis of sexual identity.
Yeah, good.
And that, it isn't yet totally in the strict scrutiny category. And the sense is probably in the next couple of years, depending on how the Supreme Court rules, it could well be there in that strict scrutiny category, which means it would be almost impossible to discriminate there. And by the way, we need to point out that in these situations, we're not just talking about the government discriminating, but we're also talking about jobs and opportunities.
Sure.
So we're talking about
Housing.
private businesses, we're talking about housing, we're talking about the opportunities that society provides. And are they open to everybody equally? So this is a real reach beyond previous powers that the government has.
Absolutely.
And it needs to be seen in that context. Again, this is a really radical thing we're talking here. And so some discrimination, good. Some discrimination, very bad. And it's up to the Supreme Court to figure out where you draw that line.
But your freedom to discriminate has been eliminated.
On certain things.
Correct.
On
I
certain
mean,
things.
to universally discriminate according to your proclivities and taste.
Right. You need to be very, very careful. And, you can't just look at this at a national basis. You also have to look at the state you live.
Yeah.
Because each state can make their own rules, and some states are much more stringent about this than other states, saying you can't discriminate against them. If you want to have a job in Oregon, for example, you can't discriminate on this basis of sexual orientation, for example. You
Sure.
just can't do it. And if you don't like it, well, get out of the state.
Move. Well, that's always been my solution.
So-
You don't like it here, don't like the rules here, move.
There you
But what's
Go
interesting, what strikes me about all these Civil War amendments is that clearly it's the new reality of 4 million emancipated people that are driving this. Yet we're starting to take a look at universal
Right.
human rights. White, black, brown, yellow, whatever.
Right. And I don't know if the framers of this amendment really thought that through. Did they, and this would be a question for historians, when they were writing this for the 4 million former enslaved people, did they think it would include Native Americans?
No.
It never occurred
No, I
to
mean,
them.
now I don't have a footnote on this, so I'm just going to make a historical judgment here. I think that this was a reactionary bunch, and they're reacting to what they're seeing going on in the South.
And so they want to whack it down.
They're wanting to whack it down and preserve their beachhead, their population beachhead in the South, which are African Americans.
And their words that they used were broad.
Yes.
It's not a limited amendment in any way.
Well, and the reason
so therefore
being,
it can be applied to other groups
It can
as
be
well.
applied to other groups, but if they said, hey, this only applies to these people, these newly freed people, then you're not going to have a whole lot of support for it.
Right.
So you got to make it colorblind, which is genius, but it also has some interesting impacts,
Developments. Impacts,
downrange, as
Yes.
they say. Okay.
Yeah. Okay.
So that's that part of the 14th Amendment, but there's more to come on the next segment of the 14th Amendment as we go through the Constitution line by line.